Well, journalists have to be aware that in certain countries there is a reasonably well-developed law of privacy. Probably in other countries, in different parts of the Commonwealth, the law might not be so well developed. But at the moment, at least in this country, in England, the underlying principle is, does the subject of the journalist's investigation have a reasonable expectation of privacy? And if the answer to that question is yes, then you then have to go to the next stage and consider whether there is a public interest in publishing and publicising that information which overrides the original reasonable expectation of privacy. So it's a balancing act that has to be carried out by the journalists and by the lawyers. The important thing to remember is that in most countries throughout the Commonwealth, the law makes a distinction between something that's in the public interest and something that is of interest to the public. And judges throughout the Commonwealth have repeatedly said that just because something might be of interest to the public doesn't make its publication in the public interest. And that's quite a difficult distinction to draw. Every case depends on its own facts, and every journalist has got to make that decision. But as I say, just because it might interest your readers, that doesn't make publication in the public interest.